Hello and good morning, everyone. Thank you for joining us today. My name is Marissa Streckfus. I'm the claims manager for RT Pro Exec located in Bloomfield, Connecticut. I would like to welcome you to this webinar brought to you by RT Pro Exec, the Management Liability Division of RT Specialty. In our webinar today, we are going to be discussing key developments during 2024 in the directors and officers liability arena. We are fortunate to have with us this morning my colleagues, Kevin LaCroix and Chris Bertola. Kevin is an executive vice president of RT Pro Exec in our Ohio office. Kevin has been involved with D&O liability issues for over 40 years. He is also the author of the D&O Diary. Chris Bertola is a broker with RT and is located in our Bloomfield, Connecticut office. Chris is one of the co-heads of our group's private management liability team. And Chris has been involved in D&O for over 15 years. Before we get started, just a few words about Ryan Specialty. Ryan Specialty is a leading international insurance firm that offers wholesale brokerage services, delegated underwriting expertise in the form of binding authorities, numerous national programs, and over 30 highly specialized managing general underwriters and other services designed for brokers, agents, and insurance carriers. Ryan Specialty's shares are listed on the New York Stock Exchange and trade under the ticker symbol RYAN. Most of you on today's call may know about RT Specialty's practice group for professional and executive liability lines, but some of you may not know that RT actually currently has 11 practices and RT binding authority and 16 industries. And for further information about RT's practice groups, please visit the RT website at www.rtspecialty.com or just contact any of the three of us after the webinar. Before I turn it over to Kevin, just a few housekeeping pointers. Our audience members today can ask questions of us using the Q&A function, and you may also do so anonymously if you choose. Chris will be screening the questions and will pass along as many of them as he can during the course of this webinar. We will do our best to answer your questions as they come in, but if we are unable to, please feel free to contact Kevin, Chris, or me after the webinar at any time. Copies of the slides from today's webinar and a link to the recording of today's session will also be made available via email to all registrants within a day or two after the completion of the session. We are also very interested in your thoughts about today's webinar. We would be very grateful if after this session, you could drop one of us a note to let us know your thoughts about today's session. The final slide has our email addresses. And with that, now I'm going to turn this over to Kevin to lead our discussion. Kevin, please take it away.
Thank you, Marissa, and good morning, everyone. The first thing I'm going to talk about this morning is the Trump administration. The largest news in the D&O arena is also the largest news in general from 2024, and that's that next Monday, Donald Trump will be inaugurated for a second term as president of the United States. And that has implications from a number of different perspectives. What I want to talk about are three ways that it's going to have important implications for the world of D&O and D&O liability and insurance. The first of the three ways is with respect to judicial appointments. During his first administration, Donald Trump appointed 234 federal judges, roughly 28% of all the sitting federal judges. Not only that, he appointed over 50 federal circuit judges as part of that 234, and perhaps most importantly, 3 Supreme Court justices. When he takes the oath of office next Monday, and when he returns to the Resolute desk on Tuesday morning to begin his term, he will have over 40 judicial vacancies to address. In his first term, Donald Trump had a proclivity to appoint young and conservative judges, and the likelihood is those young judges will continue to serve for the years ahead. And the likelihood is that by the end of his upcoming term, that he will have appointed over 50% of the sitting federal judges, meaning that his appointees will be affecting the course of federal jurisprudence for years to come. The second way that the return of Donald Trump to the White House could affect the world of D&O liability is through his appointment powers to the executive branch, and particularly his appointment powers with respect to the SEC. He's already indicated that he intends to appoint as the head of the SEC Paul Atkins, whom was a commissioner in prior Republican administrations. He's been described by the Wall Street Journal as the anti-Gensler. Most of you who are listening know that Gary Gensler, the outgoing SEC chair, took a proactive approach both with respect to enforcement and with respect to regulation. And the likelihood is that the SEC under Chair Atkins will take a different approach both with respect to enforcement and with respect to regulation. There are two particular areas that I think commentators agree that he will take a different approach, and that's with respect to crypto, where he has been very active during his term out of government, and with respect to ESG. He's been very vocal in his criticism of the Gensler administration and the policies of the SEC under Gensler with respect to ESG. And there's widespread speculation that one of the things Atkins will do as SEC chair is either withdraw or not enforce the climate change disclosure guidelines that the SEC introduced in March 2024. There's also a lot of speculation about what the enforcement approach will be, and perhaps for this audience, one of the most important things that's being discussed is that he will take a more aggressive approach with respect to individuals as opposed to entities. As I'm going to be commenting in subsequent topics, there are very specific ways he will address the SEC's approach with respect to certain substantive topics I'm going to be discussing. The third way that Donald Trump will affect the world of D&O and D&O liability and D&O insurance is the ways that his political and economic policies affect the business environment. And there are three specific things I want to talk there. The first has to do with policies that he's also made clear are going to be emphasized in his administration. And we can optimistically hope with respect to, for example, deregulation and tax cuts, that will be beneficial and helpful to the corporate and business environment, at least in the short run. But with respect to some of his other policies, he has indicated, for example, that he's going to impose tariffs on a wide variety of countries, including those that traditionally are U.S. allies. And he's also indicated that he's going to pursue a policy of deporting immigrants who are in this country without proper authorization. Both of these could have potentially complicating effects for some businesses. The policy with respect to tariffs could potentially complicate, for example, the auto industry, which imports many of its constituent parts from overseas, or the agricultural industry, which could be subject to retaliatory tariffs in response to the tariffs that Trump has proposed. The proposal to deport illegal immigrants could affect a number of industries that depend on those individuals for those individuals as their labor source. And the industries that are most likely to be affected by the deportation policies are, for example, agriculture, construction, and hospitality. I emphasize the importance of these policies because we've seen in recent years that issues such as supply chain disruption, inflation, and labor supply shortages could lead to corporate and securities litigation. And those of you who recall the impact that the pandemic had on the American economy saw there was definitely a trend in the sort of 2020 to 2022, 2023 timeframe of lawsuits from those potential economic causes. So I've been talking for a while, Marissa. I'm going to pause there and see if you have any questions, see if there's anything that I've raised that you would like to question.
Yeah, absolutely. Obviously, a lot to think about here in this first topic. But Kevin, you did mention how many judges President Trump appointed during his first administration. So how does that compare with the number of judges President Biden appointed during his last 4 years? And what do you think that means?
It's really interesting. President Trump appointed, in his first administration, appointed 234 federal judges. Biden appointed 235, just one more. So almost the identical number. And interestingly, that means that between the two of them, they've appointed more than half of all of the sitting federal judges, the others having been appointed by George W. Bush, President Clinton, and so on. But in the scorekeeping between Biden and Trump, I think that the most important thing is that Trump appointed 3 U.S. Supreme Court justices, whereas Biden appointed only 1, which clearly has a huge impact in terms of the overall constitutional issues and the overarching issues that affect the economy, civil society, and so on. So, time will tell how many appointments President Trump will get, in his upcoming term, particularly with respect to the Supreme Court. But as I said, when he shows up for work on Tuesday morning, he will have over 40 appointments to fill.
Yes, absolutely. And Kevin, I did want to ask one other question on this particular topic. So I've read in press reports that President Trump's return to the White House might affect mergers and acquisition activity. Do you agree with that? And how do you think that will affect the D&O litigation arena?
There have been some stories in the Journal and the Times over the last few days that M&A activity could pick up under the Trump administration. And the source of those opinions has to do with anticipated changes in the enforcement approach of the antitrust division of the Department of Justice and of the FTC. But also, I think there's just a feeling that the spirits of the financial markets will be more inclined and be more bullish. Whether any of that is true, time will tell. The one thing I will say that is important for this audience, because I think most of the people in this audience that are familiar with D&O claims know that M&A activity is a fruitful source of D&O claims, not just the traditional merger objection lawsuits, but lawsuits having to do with valuations, and then the post-transaction lawsuits over integration and whether the merged company lives up to the proposed advantages that were cited at the time that the merger was announced. So I don't know whether it's true or not, but it's definitely something to watch. And to the extent it is true, I think it could mean the possibility of increased D&O claims activity. Chris, I've been letting Marissa ask questions. Are there any questions from the audience? Anything that you have there on your desk?
Yes, Kevin. Do you think the Atkins SEC will retract the recent cyber disclosure rules, or just take a more hands-off enforcement approach?
It's a great question, and actually one that I'm going to touch on when I come to ESG, but I'll answer it briefly now. The short answer is, of course, I don't know, and in fact, no one knows. But I have seen some people whose opinions I respect suggest that it is a possibility that he might withdraw or non-enforce the cyber disclosure guidelines. And obviously, that could have important implications that I will circle back to when we're talking about ESG-related issues. In the interest of time, I think I'm going to press ahead. So Deirdre, if you could move to the next slide. I'm going to be talking about securities class action filings in 2024. But before I do, just a brief comment on why we talk about securities class action filings. It's something that the D&O underwriters watch, first of all, because it's a very important sign that tells them clues about their expected profitability for any given claims year. But it's also important data for them as they try to figure out what their profit-making price is and what they need to charge within certain industry classes and so on. So it's something that the D&O underwriters watch very closely. And with that lead in, let's move to the next slide, Deirdre. And this is going to be a familiar slide to most of you listening today. It reflects by year the number of securities class action lawsuits filed. A couple of things about the slide. Number one, it's only with respect to federal court securities class action lawsuit filings. It does not include state court securities class action lawsuit filings. The other thing I want to point out is that I think there's a very distracting hump there in the middle that I think just naturally attracts everyone's eyes. That's the years 2016 rather through 2020. And you'll see the significant blip up in those years. It's very distracting, and there's basically one cause for that increase, and that was the number of federal court merger objection class action lawsuits that were filed during those years for a number of reasons having to do with case law developments and behavior patterns among the plaintiffs bar. Beginning in 2020, the plaintiffs' lawyers stopped filing those lawsuits as class action lawsuits. They're still filing them, but not as class actions, rather as individual actions. And that's where you see that big drop starting in 2019 and going through 2020 to 2021. I emphasize that because I want everybody to just imaginatively, if you can, subtract those years 2017 through 2020 and really 2016 through 2020 and look at the years that precede and follow, and then compare that to the 2024 year, and you'll see that 222 number for 2024 in a historical context stands out. If you compare it to, for example, to the years 2012 through 2015, you'll see that, and also the years 2021 to 2024, you'll see that 222 is a significant number of lawsuits. It also represents a 4% increase over 2023, and it's the highest number since 2020. I could do an entire webinar just on this one slide, but I'm not going to. I'm just going to emphasize a couple of points. If we could turn to the next slide. One of the questions I always get when I start by talking about the fact that there was an increased number of lawsuits is why? Why was there an increased number? And this lawsuit goes to some of the reasons, and that's that there were some what I would call theme-based filings that I think helped increase the overall total. And here I've listed the number of lawsuits and the percentage that each of those kinds of lawsuits represents as a portion of the whole. So we've got the COVID filings, the SPAC-related filings, the crypto filings, and the artificial intelligence filings. I'm going to be talking more about the AI filings in the next section, but I just note that those trends, the COVID, SPAC, and crypto, have been trends for several years. Time will tell whether they will continue in 2025, but the likelihood is that they will continue to affect filings in 2024. If you could, in 2025, excuse me, if you turn to the next slide, thank you, Deirdre. Another question is who's getting sued? And this slide just breaks down two of the industry groups that had the highest numbers of securities class action lawsuits in 2024. Do you have any questions about the securities litigation data?
Yes, I do. Thanks, Kevin. So you had mentioned in your statistics that you discussed only relate to our federal court securities class action filings, and that those statistics don't include state court security class action filings. So how big of a deal is this? And are there a lot of state court securities lawsuit filings these days?
It's a great question. Just a quick bit of history. Most of you may recall that in 2016, there was a U.S. Supreme Court decision called Cyan that held that there is concurrent state and federal jurisdiction for the liability provisions of the 33 Act, most pertinent to IPO companies and companies conducting secondary offerings. And after that decision, there was a flurry of state court securities class action lawsuit filings. Subsequent developments, subsequent practices, including the adoption by IPO companies of forum provisions in their bylaws and articles of incorporation, have limited the availability of the state court forum for those kind of lawsuits. But those lawsuits do continue to be filed, and they are definitely important when you're talking about litigation frequency for IPO companies. And so they are still important. But I will say for the larger trends, that the number of state court filings have become sufficiently few that when you're talking about overall litigation trends, and also when you're trying to get to the granular level about industries and so on, that the federal court data really is driving and so the conclusions we can draw from the federal court data really are important. So Chris, do you have any questions on your end?
Yes, Kevin. Do you see any correlation between the security filings during Trump's last term and what might happen in the next few years?
Actually, that's a really good question. Hats off to the person that asked that. I haven't previously thought about that. I have to be honest. You'll recall that during his administration from 2017 to 2020, I'm sorry. That was a period where there was very significant securities litigation activity, but that was largely driven by the merger objection litigation. There still was other significant litigation. So, I honestly don't know the answer, but I can say if I were to go back and look now, one of the questions I would ask is how distorting was the merger objection litigation, and what can we discern about the other litigation that was filed? And in all candor, I don't know the answer to that question, but it's a great question. Anything else on that part, Chris?
That's it. Thanks, Kevin.
Okay, well, great. With that, Deirdre, if we could move to the next topic, that would be terrific. So one of the hot topics, really in financial markets and in our space in D&O, has been artificial intelligence. And it as a market phenomenon, it's one thing. We really need to drill down on what it may mean in terms of the enforcement actions that are being filed, the private lawsuits that are being filed, and the regulatory actions that legislators and other actors are taking with respect to AI. So if you could turn to the next slide, Deirdre. At the end of 2023, SEC Chair Gensler issued a statement warning companies about so-called AI washing. It's an echo to what I think most of you will know as greenwashing, which was in that context overstating the sustainability credentials of companies. Well, AI washing is overstating the capabilities and prospects for companies of their AI strategies. And picking up on the chair's warnings about AI washing, there have been enforcement actions in 2024 in which there were AI washing type allegations. And I note here on the slide the enforcement action that the SEC filed against Kubient, that in connection with its IPOs allegedly made representations about its AI-based capabilities for detecting fraud in internet-based advertising. I emphasize the Kubient. It was only one of several AI-related enforcement actions the SEC filed in 2024. But I emphasize the Kubient one because it was the only one involving a public a reporting company. All of the other actions, as noted in the final line there on the bottom of the slide, against investment advisory firms and other commercial firms, all of them were private companies. So I emphasize that just for those of you in the audience that aren't active in the public space, that this is a concern not just for public companies, but also for private companies too. One final point is that the SEC is not the only actor in the space. The FTC brought 5 enforcement actions in September 2024 under its so-called Operation AI Comply, also having to do with misrepresentations various companies made to consumers about their AI capabilities. If you could go to the next slide, please, Deirdre. In addition to the enforcement actions, there have been AI-related securities lawsuits filed. And as I noted in a prior slide, there were 13 AI-related securities class action lawsuits in 2024. Literally all or almost all of them involved AI washing type allegations. That is, that the allegation was that the company had misrepresented its AI capabilities or prospects in an effort to try and catch some of the fire that's burning in the financial markets about AI related companies. I want to raise for the audience today, thinking about what kind of risk AI might be from a litigation standpoint going forward, and suggest that perhaps the greater area is not with respect to AI washing, but it's with respect to the possibility of misrepresentations concerning the risks of AI to companies. And I want to use an actual example. It didn't involve litigation, but it involved a circumstance that I think makes the point. There was an article in the Wall Street Journal in November 2024 about a company called Chegg, which is in the business of providing subscription-based, internet-based homework help. And this isn't just like with your book report. This is like, for example, with respect to coding and other, high-level kinds of work that students might require at various levels of education. Well, the reason they were in the Wall Street Journal, which is unfortunately the company has lost in the preceding 12 months, 99% of its stock market value, because its subscribers were finding that they could get the homework help they needed by using ChatGPT. basically AI ate up their business model. And I think it's a good example to think about when we're thinking about the litigation risk going forward, not only because it involved alleged omissions or misrepresentations with respect to AI related risk, but it was third party conduct, with a competitor conduct that caused the problems. So I think it's a good example to think about when you're trying to, figure out where claims might be coming from in the future. If you could turn to the next slide, Deirdre, there's one other area we need to talk about with respect to AI, and that's with respect to regulatory risk. And it comes in two basic flavors. The first is as derives from the EU Artificial Intelligence Act, enacted in March 2024, which is applicable to all companies creating or using AI in the EU, regardless of where they're located, which means that many of our client companies may find themselves subject to this act. It has various bans on the use of AI, particularly for synthetic content or in ways that may introduce bias, but it's subject to various security, transparency, and privacy issues. The potential sanctions are steep and could be quite significant for companies. And so it's a concern not only for companies that may find themselves subject to regulatory action, but also for possible follow-on private litigation by investors or others as a follow-on to regulatory action. There's significant state legislation as well. There isn't comprehensive federal legislation, nor do I anticipate any in the current Congress, but the state activity could be significant. And there are a number of states, and I list them here, and there are many others that have either enacted or are considering state level legislation focused on consumer rights, privacy, bias provisions. And I think the landscape is going to be, with respect to AI, kind of similar to where we are with privacy, where there are state laws that create sort of a hodgepodge of regulatory concerns for companies doing business in the United States. But I will say, with respect to the state legislation, as I said, with respect to the EU Act, that the risk is not only regulatory activity, but the possibility of follow-on civil litigation. So just to summarize what I think with respect to AI as a risk going forward, there's a risk of SEC or FTC type enforcement activity, and it remains to be seen what that activity will look like under the new administration. The next is the possibility of private civil litigation, and I anticipate there will be more, although it may look different in 2025. And then third, there will be the regulatory risk, primarily, I think, from the EU Act, but also from the state legislation as well. So I'll pause there. Marissa, any questions from you with respect to AI?
Yeah, Kevin, this is obviously a really interesting and sensitive topic these days. And I know that you talked about a number of AI-related lawsuits that we've seen been filed. Have they proceeded enough that we know how they're faring in the courts yet? And have we seen any significant settlements related to these AI suits?
Yeah, that's a good question, Marissa. And I wish I had better data to cite. Unfortunately, most of the cases, particularly the ones filed most recently, are still in the early stages, so they haven't developed. It's definitely something to watch, because I think up to this point, the plaintiffs' lawyers have shown an interest in this as sort of a product area for them. But I think they'll be watching closely to see whether it proves to be profitable for them. I will say this, the fact that it's about AI, it makes it so that we can kind of identify them and put it in a classification. But truthfully, the allegations are very similar to sort of traditional securities lawsuit allegations. So I think they will thrive or fail pretty much the way similar type lawsuits that have different kinds of allegations thrive or fail. I don't think it's going to be categorically different. I think it'll be somewhat similar, at least based on the lawsuits that have been filed so far. Chris, any questions from the audience?
None at this time, Kevin.
Okay, great. Well, if that's the case, I'm going to move on to the next topic, which is ESG. I think everybody in the audience knows that ESG has been a perennial topic historically. It's been high profile, and certainly one that I've talked about in the equivalent webinars over the last several years. But the truth is that as a topic, it has changed, and it's changed significantly. If you could turn to the next slide, please. if we go back 3-4 years, I think everyone can recall that the dynamic was that companies were under pressure to demonstrate their ESG credentials and show that they were good ESG citizens, although that very quickly became somewhat problematic for some companies as they faced so-called greenwashing claims that they had overstated their sustainability initiatives or capabilities. And then, as particularly in the United States, an ESG backlash developed as conservative advocates and politicians targeted companies that had been proactive on ESG matters. And that in turn led many companies to try and lower their profile to take a soft approach to their ESG disclosures, a phenomenon that's been called green hushing. If you could turn to the next slide, please. Those trends of the change in ESG continued as during 2024, and there are several different developments during 2024 that I would cite as evidence of that continuing evolution. From a symbolic standpoint, one that I think is particularly important is the fact that during 2024, the SEC quietly disbanded its climate and ESG task force. And in fact, it had been disbanded for several months before it actually came to light. I think the fact that the SEC found it expedient to disband it and the fact that it found it expedient to do it quietly says a lot about how much the topic has changed. Although, as I will point out in a minute, even after the ESG disbanded the task force, it continued to take ESG related enforcement actions. A significant related development pertaining to ESG is the fact that as a result of activities by advocacy groups, many high-profile companies have found it political, I believe, to walk back their DEI commitments. And on the slide, I cite Ford and Walmart. There have been others, Harley Davidson, Home Depot. Just this week, Meta, the parent company of Facebook. So it's obviously a trend that it has taken place in corporate America. And along the same lines, in December 2024, the Fifth Circuit, acting en banc, struck down the NASDAQ's, the SEC's approval of the NASDAQ's board diversity guidelines. We now have, the new administration coming in next week, and the mainstream press has asked the question whether the DEI pushback will continue under the Trump administration, and I believe the consensus there is that it will. With respect to ESG-related issues, the question that I raised before is whether the SEC will withdraw or not enforce the climate change disclosure guidelines, which clearly could impact the role of ESG going forward. You could turn to the next slide, please. Even though the SEC did disband its climate change task force in 2024, there were SEC enforcement actions filed during the year, including the example I've cited here in the left-hand box there relating to Keurig Dr. Pepper, which was filed after the SEC had disbanded the task force. But the enforcement action was a filed as settled enforcement action related to sustainability claims the company had made concerning its self-serve coffee pods. I think it's also important to note that in addition to the enforcement activity, there were private lawsuits that contained allegations that were supportive of ESG values. Between the SEC and these private lawsuits, I think it shows that not all of the ESG activity is in the same direction. And that's one of many reasons I think that ESG as a topic is not going away. If you could turn to the next slide, please, Deirdre. I want to emphasize that just as was the case with respect to AI, regulatory constraints are an important issue with respect to ESG. And just as was the case with respect to AI, it's also the fact that the EU's regulatory activity is important to discuss. And the EU has adopted sustainability disclosure requirements that apply not only to EU companies, but to non-EU companies that have specified levels of EU activity. And therefore, both the EU companies and the non-EU companies with those levels of business activity in the EU will have disclosure requirements. And those disclosure requirements run the gamut across topics such as climate change and other corporate responsibility type issues. And I note here that according to one survey, as many as 3,000 North American companies may be subject to those EU disclosure requirements. In addition, in the final line on the slide, I note that California does have climate change disclosure legislation that, though it's subject to pending litigation, remains in place. And so between the EU requirements and the California state requirements, many companies may find themselves having to deal with climate change disclosure, even if the incoming administration does withdraw the SEC's climate change disclosure guidelines. So for my money, I don't think ESG may change. It may, even the label ESG may fall by the wayside, but I don't think the constituent issues are going to go away. I think they're going to continue to be important, and I think they will remain an important part of the D&O liability environment. Marissa, any questions about ESG?
Yeah, Kevin. So we talked about a lot about how the Trump administration is likely to make changes and the potential for the SEC to withdraw the climate change disclosure guidelines with the new administration. And, similar to we still have shareholders and stakeholders filing securities and derivative litigation on ESG style issues. What do you think this might mean for the future of climate change related D&O litigation in the new administration?
Yeah, it's a great question. And before I'd answer it, I want to level set a little bit. And it's just to concede to this audience that going all the way back to 2007, I had been predicting that there would be significant climate change related D&O claims activity. And continuously throughout the period since 2007, I've been wrong on that issue. There has not been significant climate change related D&O claims activity. I think the changing political environment, which we've seen most prominently with respect to DEI, and also the likelihood that the SEC will withdraw or not enforce the climate change disclosure guidelines, definitely changes the prospects for future climate change litigation activity or even DEI related litigation activity. I will say, I think that one thing none of us in this space can take our eyes off of is that I think corporate boards are making decisions today that in the 5 and 10 year time frame are going to be subject to hindsight second guessing, and companies that are not watching carefully the wildfires in California or the extreme weather events that have taken place, for example, in Saudi Arabia and other jurisdictions in recent periods, and taking that into account in their plans for the business operations, they may well find themselves subject to, corporate and securities type litigation activity down the road based on decisions they're making or not making today. So I think it's easy to say, well, the environment looks like it's changed and it may be a less threatening environment under the Trump administration and given the current political environment. But I think that for long run purposes, corporations who go to sleep on this issue could, in the long term, be very sorry that they weren't more proactive and more self-conscious on this issue. So Chris, any questions from the audience on this issue?
Yes, Kevin. In regard to ESG, could you say that green hushing is the most prudent approach for companies moving forward?
Well, I'll say this, I certainly understand why, given the political environment, companies have decided that keeping their heads below the parapet is the safest thing to do. And it's probably what I would do if I were responsible for a company. But I want to emphasize that I think green hushing itself talks about what the company's saying publicly. But I think regardless of what they're saying publicly, there needs to be decision-making going on behind the scenes. And that, responsible corporate boards, well-advised corporate boards, even if they're taking an approach to soft pedal what they're saying publicly, still are going to want to make sure that they have these kinds of issues on their agenda. When I look at some of the anti-ESG litigation that's been filed in recent months, I think for now, green hushing probably is about the only approach that companies may feel they can safely take. But I hope that as the circumstances evolve, we can get to a more nuanced and more responsive environment where investors are getting all of the disclosures they actually need to make prudent investment decisions. Any other questions on ESG, Chris?
Last one, Kevin, is could companies abandoning previous ESG policies result in derivative suits?
Yeah, I can definitely see it. I had an example on a prior slide of a lawsuit that was filed this year against Lululemon, the apparel company. And the allegation was that though the company had adopted DEI principles and guidelines, that in fact, those guidelines did not counteract discriminatory hiring and other activity at the company. So I think, steps that companies take or don't take are always going to be subject to hindsight scrutiny. And I think actions that companies take or don't take, including even green hushing, could, through the lens of a particularly opportunistic plaintiff's lawyer, be portrayed in a way that they will try and characterize as subjecting the company to violation. I don't think there's a way companies can ever escape that kind of scrutiny. And I think it's particularly in the United States, and particularly the political and litigation environment surrounding ESG issues these days. I don't think there's really any surefire way to avoid that kind of potential liability. Any other questions on that topic, Chris?
That's it. Thanks, Kevin.
Thanks, Chris. If we could move to the next slide, please, Deirdre. Cybersecurity is clearly another perennial issue, one that we always talk about. If you could turn to the next slide, Deirdre. I think the starting point for talking about cybersecurity, at least in the year that's passed, probably is the February 2024 settlement involving Alphabet, the corporate parent of Google, which paid $250 million to settle the Google Plus data breach lawsuit, which is, as far as I know, the largest ever cybersecurity-related securities class action lawsuit settlement. I think the relevance to the discussion is, as long as there are recoveries like that out there, plaintiffs' lawyers are going to find it expedient to try and pursue these kind of claims, and will likely continue to file those kind of claims. If you could turn to the next slide, Deirdre, that in 2024, there were cybersecurity cases filed. I want to talk about two because I think they're interesting in showing in another way how cybersecurity as a D&O risk has changed. The first example there on the left, the July 2024 lawsuit filed against CrowdStrike after the massive IT outage the company sustained following an unfortunate software update. And by the way, I just want to compliment my marketing colleagues for the picture on the slide. On July 19th, 2024, I was in a scene in O'Hare Airport, Chicago, that looked very much like that, and it brings home very bad memories for me. I'm sure most of you remember that incident. Within days, there was this securities class action lawsuit. It potentially or arguably represents a different kind of cybersecurity lawsuit because it wasn't a data breach, there wasn't an intrusion, there wasn't a bad actor, but there was a massive network outage. So it to that extent represents a network security issue. Reasonable minds could differ about whether it actually is a cybersecurity lawsuit at all, but I think it just does show how circumstances are changing. The risks that can arise from network security issues can change. And I've cited another example there the PDD Holdings lawsuit, which is a Chinese internet-based service company on its app introduced what we would describe as malware that allowed the company to infiltrate the operating security of their customers' phone systems, so they could surveil the text messaging and other activity on their customers' phones. So it's not a data breach in the classic sense, because there was no intrusion by a hostile actor. The hostile actor was the company itself. So it shows how there's yet another variant on cybersecurity as a source of potential D&O litigation activity. I think that will continue to change as circumstances change, as technology changes. If you could turn to the next slide, Deirdre. Just to emphasize that cybersecurity enforcement continued, at least under the Gensler administration, and there were high-profile cybersecurity enforcement actions brought by the SEC. The first example was R.R. Donnelley, where its disclosures with respect to a cybersecurity incident were alleged by the SEC to represent a breach of the company's obligations with respect to its accounting controls. The second example, 4 companies were targeted by the SEC in enforcement actions with respect to the impact on their companies by the SolarWinds data breach. And one of those cases also involved an instance where the cybersecurity, the incident-related disclosures by the company were alleged to be a breach of the company's accounting control obligations. One thing we have to ask, though, is will this kind of enforcement activity continue in the incoming administration? And there, let's please turn to the next slide. I want to talk about, if we just set aside for a moment what I think would have been the big issue in 2025, were it not for the change in administration, and that would be with respect to the cyber disclosure guidelines, which went into effect in December 2023 and have disclosure requirements both with respect to cyber governance controls and incident-specific reporting. And there was a study by the Paul Hastings law firm, I cite in the second bullet point there, that between December 2023 and October 2024, 48 companies made 75 cyber incident disclosures, representing a 60% increase in the number of cyber incident disclosures filed with the SEC. The question we all have to answer is, what's the new administration going to do with the cyber disclosure guidelines? And again, I have seen comments from responsible commentators that under Paul Atkins, the SEC will either withdraw or non-enforce the cyber disclosure guidelines. I think we need to be careful, because I think perhaps aspects may be withdrawn. I don't know necessarily that we can assume that cyber incident disclosure requirements are going to be withdrawn. And even if the specific guidelines are withdrawn, there still will be general materiality obligations and so on. So what it's all going to mean remains to be seen, and it could be a complicated picture. The one thing I will note that is, in the enforcement actions I noted in the prior slide, the Republican commissioners dissented, and I think they signaled some of the changes that will come in the new SEC under Paul Atkins. And in particular, we may see less enforcement activity where violations of cyber incident disclosures are held to represent shortcomings in the accounting control environment. Marissa, any questions from you about cyber disclosure?
Yeah, Kevin. So I wanted to go back to when we were talking about cybersecurity related D&O lawsuits. Have there been as many as you expected there would be, and why do you think that's the case?
Yeah, this is another area where earlier on I was predicting levels of activity greater than what actually occurred. And the reason I think there's been less traditional securities class action activity, at least, is that the investment marketplace, I think, has gotten inured to the news of cyber incidents, and that for many companies that experience data breaches or other cybersecurity incidents, their share price doesn't move. And so it's in that circumstance, it's of less interest to the plaintiff's lawyers because that clearly diminishes the magnitude of potential damages they might be able to recover. And so it's just not all that interesting to the plaintiff's lawyers. There still will be securities class action lawsuits filed, particularly when there are share price drops, but that's just not been a part of the security disclosure environment. Chris, any questions from the audience?
None at this time, Kevin.
Great, thanks, Chris. If we could move to the next slide, I'll very quickly cover this last topic before we wrap up. I just want to emphasize a point that I pretty much made when I was talking about the incoming new administration, is there's going to be a lot of changes, and with those changes come geopolitical risk. If you could turn to the next slide, Deirdre. We saw examples in 2024 of companies who experienced securities class action lawsuits as a result of various type of geopolitical concerns. And both of these examples involve companies who ran afoul of export controls or other constraints on doing business with Russia in the wake of the Ukraine war. And I think they just serve as examples to show how these type of macro geopolitical concerns can wind up translating into D&O claims. If you turn to the next slide, Deirdre, the kinds of geopolitical risks that we can identify, at least at this point, include familiar topics. These have been around for years, but I just feel that in the changing environment could become of increasing concern. For example, money laundering, trade sanctions, and the two prior examples of the two companies that were sued with respect to doing business in Russia are good examples of that. Export controls, and there, you could also probably tie in tariff-related issues, Foreign Corrupt Practices Act, the cross-border issues related to digital assets. I think that the geopolitical risks could take a variety of different forms. Any questions from you on that topic, Marissa? You're on mute, Marissa.
Apologies, Kevin. Thank you. So,
worries.
do you, in addition to these other geopolitical risks, do you think that cybersecurity is also one?
That's a massive one. And I'll just cite a Wall Street Journal article, I think it was last week, about how China-based state actor infiltrators supposedly have implanted themselves in the security systems, the network systems of a variety of telecommunications, other communications companies, as well as throughout various other types of infrastructure. State-based actors, for any number of reasons, might seek to exploit those type of vulnerabilities, which clearly could have a significant impact on the particular companies whose facilities are infiltrated, but on companies that depend on those businesses as well. So yeah, clearly cybersecurity is definitely another concern. Chris, any questions from the audience for you?
None at this time, Kevin.
Thanks, Chris. With that, I think we'll move on to the next slide, if we could, Deirdre, and talk about the last topic, which is, what does this all mean for the D&O space? And if you could turn to the next slide. I think with everything we've been talking about, it would come as no surprise that underwriters may feel cautious, and then they might even use that caution as a trigger to try and implement pricing increases. And while I will freely concede that might be a rational response, I think market constraints will limit the extent to which companies are able to pursue that type of approach. And the reason why that's so, and the reason why I think the market will remain competitive, is that there was a hard market from 2019 to 2021 that brought in new players, new capacity. And at the same time, the IPO market, the SPAC market dried up. So while there was an expansion of capacity, there was a drop in demand. And what that did is it reintroduced competition, and that led to a soft phase of the cycle, which began in 2022, and is the one that we remain in. And while I I think it is true that perhaps the decreases have plateaued for many companies, or at least leveled off. In general, especially by contrast to the harder market that was in place a few years ago, most companies enjoyed favorable pricing on favorable terms and conditions. If you could turn to the next slide. In thinking about what it might mean for 2025, just a few quick observations. The first is, as always in a soft market, there are going to be commentators who are disclaiming that the pricing it's ridiculous and it's gone below risk-based pricing levels. And on that, I think we can put a timer in the Plus D&O conference in March about how long we get into the conference piece before some underwriter complains about the pricing environment. My over-under is 10 minutes. I think you can just count on it. But the problem for the industry, and even though I understand where that sentiment comes from, is that abundant insurance capacity remains in place and the laws of supply and demand generally control. I think it's important to remember that the hard market phases are infrequent and generally short. The soft market phases are much more prevalent and much more longer lasting. And so my advice is don't get impatient, because it could be a while before we see a true market turn. And the likelihood is that for most D&O insurance buyers, they're going to continue to see a relatively favorable environment. I'm going to turn it back over to Marissa in a moment to wrap it up. But just one more slide, if you could advance one more slide. I'm sure all of you thinking, gee, that's an awful lot that's going on. How can I possibly keep up with what's going on? And I think the one way you can is to please visit the D&O Diary every day. I spend a lot of time on it, and it would make me happy if you guys could read it. With that, I'm going to turn it back to Marissa to wrap things up. Marissa?
Thank you so much, Kevin. I think we can go to the next slide, Deirdre, as well. Kevin, again, thank you as ever so much for leading our discussion this morning. And before we break off again, we want to remind everyone that we are very interested in your thoughts and reactions to this morning's webinar. We appreciate your patience. And if anyone, if you have a moment, please drop one of us a note and let us know what you thought of our session today. I would also like to very much thank our RT colleagues, Deirdre White and Joe Klein, for their technical help and design input. We could not have done this without you, and we appreciate you so very much. And again, thank you for your time this morning, everyone. We wish you all a very successful 2025, and we look forward to the opportunity to work with all of you. Thank you and goodbye.
Thank you, everyone.